This is Agriculture Today, and welcome back. We've quite a bevy of things to cover this time around as we talk agricultural law and taxation matters with our guest from the Washburn University School of Law. Roger McOwen is back with us once more. These are very diverse, Roger, and we'll just walk through them. They're all covered, we would note, in one of your most recent blogs on the website that you maintain. We'll refer folks to that again in just a second. The first one we will talk of has to do with who owns hogs in an instance where there was an issue about where the meat from what hogs went where. It's rather confusing. Would you explain further?
Well, Eric, these cases we're going to talk about, I think, are a good illustration of the various types of legal issues that farmers and ranchers and rural landowners face all across the country. It's just amazing the issues that come up and how the law is intertwined with daily life of the farmer and rancher. And you're right, this first one can be confusing, but let me break this down. What this is at its core is whether what we're dealing with is a good or a service. And we get into these issues in agriculture frequently in contract situations, in secured transaction situations. But what this one is a contract production situation involving hogs. And the plaintiff in this case, which is Tyson Fresh Meats, they claim they bought hogs from a company that subcontracted with a farm to raise the hogs. And so the subcontractor that's working for the firm that had signed the contract with Tyson, so that's the complexity of this, delivered 267 hogs to Tyson, and Tyson processed the hogs and commingled the meat with other meat at its plant. Well, 2 days later, the subcontracting firm, actually the firm that hired the subcontracting firm, so the actual farm where the hogs were raised, told Tyson that the hogs hadn't gone through a required withdrawal period for a certain supplement. And so that meant Tyson, under the law, had to dispose of more than 1.7 million pounds of what is now deemed to be contaminated fresh meat. And so Tyson sues for negligence and breach of state law and product liability law under Indiana law. And the farm claimed that, look, we provided a service. We didn't provide a product. Our service was raising these hogs for you based on a contract we had with you. We didn't provide a product. And because the hogs were not products, they're not subject to state product liability law. You can't sue us for that.
How did the court find on that then? And again, it's a breakdown of what's a good and what's a service.
Yeah, this goes to the Indiana Court of Appeals, and they said these hogs are goods under product liability law in Indiana because that law covers all things that are movable when they're contracted for, including the unborn young of animals and adult animals. And so they could sue, Tyson could sue under product liability law. They also sued for negligence, but on that claim, the appellate court said that Tyson had failed to adequately allege that the farm owed Tyson a duty of care. So they couldn't proceed with the negligence claim, but the hogs are goods for purposes of product liability law. So this gets into contract production. What are the items that are produced? Is it a service that they are produced under, or are they still goods? And this court said under Indiana product liability law, they are goods because that law is written pretty broadly, as many states' product liability laws are. So the hogs were goods, and Tyson could sue under state product liability law.
That's a finding of note, particularly those who might be operating under a contract production situation with an owner of the actual livestock there. Another case, and this has Kansas origins here, it had to do with the approval of a hog operation permit, and that was challenged. And tell us from there where this went.
Well, this is an environmental group that is challenging the issuance of those hog operation permits for a confinement operation. And it really comes down to the issue of standing to sue. You have to establish that you have standing to sue, meaning that you've suffered some concrete injury that a court should redress for you or has the ability to redress, has the jurisdiction to redress. And the court here said, no, Sierra Club, you don't have standing to seek judicial review on these permits. You haven't established any type of concrete injury. And so you can't challenge the statute. You can't challenge the regulations under which the permits were issued to this farm.
That's pretty straightforward. That would seem to suggest that there's good protection for those kinds of operations which apply for and receive a permit, and that they would hold up.
Well, we do see a lot of these challenges like this, and a lot of the cases come down to whether the plaintiff has standing to sue. This is one where the court determined that the environmental group, the Sierra Club, did not have standing to sue. There are lots of other cases out there where the environmental group, the activist group, whatever you call them, they do have standing to sue because they have maybe a member that lives nearby and is suffering a discernible, a discrete injury, and I put that in air quotes, from the farm. Maybe it's a nuisance type situation. Maybe it's we want to challenge these permits because we think something is going to create a problem for us. You usually can't sue for anticipated injury. You have to wait until an injury occurs, and that may be part of what's at issue here. But often we will see the court say that there is standing in a particular case because a group has a member that they can sue on behalf of, and that member has suffered a particular injury. Didn't have any of those facts in this case, and so the court said we don't have standing to hear the case.
That, by the way, was a ruling by the Kansas Court of Appeals in very early April. And another case based in Kansas as well, and an issue that's been boiling for quite some time, protections allowed to agricultural operations from infiltration of their operations for purposes of gathering evidence. This has been bandied about quite a bit, hasn't it, Roger?
Yeah. This is the Kansas so-called ag-gag law. I hate that phrase, but that's the way it's commonly mentioned, and that's the way people recognize it. No secret filming inside slaughterhouses, confinement operations, those types of things. Well, those have been challenged by various activist groups, and this one is a challenge by the Animal Legal Defense Fund as being unconstitutional, and unconstitutional in terms of violating First Amendment free speech rights. And largely the courts have said, yeah, that's right, although the Eighth Circuit in an Iowa case made a distinction with respect to the Iowa statute. But Kansas had the first statute in the nation on this, enacted about 30 years ago. The Attorney General made a decision to ask the Supreme Court to hear the Tenth Circuit opinion, which struck down the Kansas law last year on this. And the Supreme Court just recently, just a few weeks ago, decided, no, we're not going to hear this case. And so they're going to let that one stand. But I would say this, Eric, there are other challenges that are out there. We have an Eighth Circuit opinion. We have a Ninth Circuit opinion. Those are not directly on point with each other. There's some discrepancy there. And so there is a reason for the U.S. Supreme Court to take up one of these so-called ag-gag cases. They just chose not to take the Kansas one for whatever reason, and we don't know why, because they don't issue an opinion when they do this. They just say, no, certiorari denied. And so this is an issue that's still going to be out there, and at some point in time, I wouldn't be surprised if the U.S. Supreme Court does take one of these cases just to clear this thing up once and for all.
Everybody in agriculture will keep an eye on that. Last one here briefly, and it's very broad, but it certainly could apply to farm and ranch families here, has to do with Medicaid rules. And if one knows the nuances of Medicaid, they understand that an individual's assets have to be fairly well exhausted before Medicaid kicks in. And this was a case where a couple in assisted living actually invested in a home outside of those assisted living quarters. Explain further, if you would.
Yeah, and the thing is, they got an interest in a home after they entered the nursing home and made an application for Medicaid benefits and started to receive Medicaid benefits. Then they get an interest in a home, and the question was, well, can they exclude the value of the home? And under the Medicaid rules, you can if you have an intent to return to the home if you're discharged from the nursing home. Okay, that's well and fine, but what if you acquire the home after you entered the nursing home? You didn't have the home at the time you entered the nursing home. That's the key in this case. What happened here was that this couple bought a home in 1974, and they lived there until 2010. They sold it to their daughter and then moved to a rental property that the daughter owned. Well, in 2017, the couple, both of them, enter a skilled nursing facility, and then shortly after they're in the skilled nursing facility, had applied for Medicaid, started getting their application gets approved. Well, after that happened, they buy a 1/2 interest in the original home, their original home that they had sold to the daughter. To secure home equity in it, so that they could return to it if one or both of them should be able to leave the nursing home. Now, the question is, can you do that after the fact and still exclude the value of the home from your resources? And they said there is no actual residence requirement under Medicaid and at the time you apply for benefits. So if you acquire a home after you or an interest in a home after you make an application, then as long as you have the subjective intent to return to that, if you leave the nursing home, then the value of that is excluded from your Medicaid eligibility computation.
And Roger has covered these articles in his blog, which can be found at washburnlaw.edu/WALTR. This was posted on May the 4th. Roger, as always, thanks for going over all of this with us right here.
Thank you, Eric.
Roger McOwen, Professor of Agricultural Law and Taxation, Washburn University School of Law, with us regularly here on Agriculture Today.